Are you dealing with harassing creditors trying to collect a debt? Wondering what they can and can't do when collecting a debt? What activities might violate the law? Today, I'd like to examine these illegal debt collection activities with you and talk about what your options are. Hello, I'm David Candler Hicks of the Alliance Legal Group. We are a Florida-based law firm that focuses on helping clients deal with debt collectors. Would you like to learn more? Join me. Many people don't realize that debt collection is actually a heavily regulated industry. The Federal Trade Commission, or FTC, the nation's consumer protection agency, enforces the Fair Debt Collection Practices Act, which prohibits debt collectors from using abusive, unfair, or deceptive practices to collect from you. Under the FDCPA, a debt collector is someone who regularly collects debts owed to others. This includes collection agencies, lawyers who collect debts on a regular basis, and companies that buy delinquent debts and then try to collect them. The Act covers personal, family, and household debts, but doesn't cover debts you incurred to run a business. The Fair Debt Collection Practices Act, or FDCPA, applies only to third-party debt collectors, not to the original creditor. Florida has its own version of the FDCPA, called the FCCPA, or the Florida Consumer Collection Practices Act. There are many similarities, but one of the biggest distinctions is that the collection entity does not have to be a third party. The FDCPA prohibits debt collectors from engaging in certain misleading or harassing conduct. For example, they may not contact you at inconvenient times or places, such as before 8 in the morning or after 9 at night, unless you agree to it. And collectors may not contact you at work if they're told orally or in writing that you're not allowed to get calls there. If an attorney is representing you about the debt collector must contact the attorney rather than you. If you don't have an attorney, a collector may contact other people, but only to find out your address, your home phone number, and where you work. Collectors usually are prohibited from contacting third parties more than once. A debt collector generally is not permitted to discuss your debt with anyone other than you, your spouse, or your attorney. Every collector must send you a written validation notice telling you how much money you owe within 5 days after they first contact you. This notice also must include the name of the creditor to whom you owe the money and how to proceed if you don't think you owe the money. If you send the debt collector a letter within 30 days stating that you don't owe any or all of the money or asking for verification of the debt, that collector must stop contacting you until it can verify the debt. One of the most important aspects of the FDCPA is the prohibition against harassment. Debt collectors may not harass, oppress, or abuse you or any third parties they contact. For example, they may not use threats of violence or harm, publish a list of names of people who refuse to pay their debts, use obscene or profane language, or repeatedly use the phone to annoy someone. Debt collectors are also barred from making false statements. For example, they can't falsely claim that they are attorneys or government representatives, falsely claim that you've committed a crime, falsely represent that they operate or work for a credit reporting company, misrepresent the amount you owe, indicate that papers they send you are legal forms if they aren't, or indicate that papers they send to you aren't legal forms if they are. Debt collectors are also prohibited from saying that you will be arrested if you don't pay your debt, that they'll seize, garnish, attach, or sell your property or wages unless they are permitted by law to take action and intend to do just that, or that legal action will be taken against you if doing so would be illegal or if they don't intend to take the action. They also cannot send false credit information about you to anyone, including a credit reporting company. They can't send you anything that looks like an official document from a court or government agency if it isn't, or use a false company name. If a creditor or debt collector has violated the FDCPA, you have the right to sue them in a state or federal court. You may also have options under state laws for administrative remedies. In addition to contacting your own attorney, you should report any problems you have with a debt collector to your state attorney general's office, the Federal Trade Commission, and the Consumer Financial Protection Bureau. At Alliance Legal Group, we help clients dealing with harassing debt collectors to find options to get their financial lives back on track. We'd be happy to discuss the circumstances of your situation directly with you and help you find appropriate options. I'm David Candler Hicks. Have a wonderful day.